Hello everyone, I'll be discussing about judicial review, cases in India and limitations. This will be my content. We all know that judiciary under Indian constitution is independent. What are the provisions which talk about independence of judiciary are Article 50 which states that the judiciary is separate from executive and Article 124 to 137 which talk about the power and constitution of Supreme Court which states that the tenure of the Supreme Court judges will be until the age of 65. In Article 214 to 247 which talk about power and constitution of high courts where the tenure of the judges will be until the age of 62. There is financial independence when it comes to judiciary. It is not dependent on executive or legislature. Then the judiciary also has the power to punish for contempt. This has been laid down under Article 129 under the Indian Constitution. Contempt are of two types, civil contempt of court and criminal contempt of court. Let us suppose that there is this person called as Mr. X who has a house and adjacent to him Y also has a house and there is a common wall. Y wants to destroy the common wall. Mr. X comes to know this and he obtains a stay order and an injunction. And Y nevertheless goes forward and destroys the common wall. This is an example for civil contempt of court. What is an example for criminal contempt of court? So let us suppose that Mr. X is arguing a matter and he accuses the judge of having an affair with the court officer in a public platform. This is nothing but criminal contempt of court. This is very similar to defamation. Defamation are of two types. It's libel and slander. Libel is when I write ill about a person without doing a background check, and slander is when I utter bad words related to a person without knowing his background or anything as such. So, this is what regarding the independence of judiciary. There are three organs of the government: legislature, executive, and judiciary. Legislature makes the law, executive implements the law, and judiciary interprets the law. In simple words, judicial review refers to the power of the courts to strike down laws as unconstitutional. Before I go forward with the explanation regarding judicial review, I want to briefly state its history. So it started with Marbury versus Madison case in the United States. So President Adams had nominated few eminent persons as judges for certain districts in United States. Before his office was overtaken by Thomas Jefferson, he had gone forward with the procedure regarding delivery of commission. But before that itself, Thomas Jefferson overthrew the office. Through his Secretary of State, James Madison, he stopped the delivery of commission from happening. Marbury was one of the judges who were waiting for appointment to district of certain district in United States. Marbury questioned this in the court of law, that to Supreme Court, and asked for a writ of mandamus to be issued. Under the Section 13 of Judiciary Act 1789, writ of mandamus could be issued to any office within the territorial jurisdiction of United States. This was not in tandem with Article 3 of the US Constitution, which spoke that writ of mandamus could be issued to public ministers, then councils, ambassadors, but not to compel judicial appointments. Also, the writ of mandamus could not be issued while invoking the original jurisdiction. Jurisdictions are of four types: original jurisdiction, appellate jurisdiction, pecuniary jurisdiction, and territorial jurisdiction. So, pecuniary jurisdiction is, for example, in India, district forums have the pecuniary jurisdiction of less than 20 lakhs, and state commissions have a pecuniary jurisdiction of between 2 to 1 crore, 20 lakhs to 1 crore, and 1 crore and above, it will fall under the jurisdiction of National Commission. This is the hierarchy when it comes to consumer disputes in India and the pecuniary jurisdiction. Then, what are the types of judicial review? First one is review of legislative action. Before the promulgation of Civil Rights Act 1964, racial segregation and discrimination was rampant in the United States. Later, in the aftermath of Brown versus Board of Education, it led to enactment of Civil Rights Act 1964. That is an example for legislative action. Then there is review of administrative actions. Administrative actions are further classified into quasi-legislative, quasi-executive, and quasi-judicial. Example for quasi-legislative is delegation of rule-making authority to delegated authority under any of the legislation. Example is Civil Servant Efficiency Rules 1973. Example for quasi-judicial action is disciplinary actions against employee for misconduct. A quasi-judicial body is bound by natural principles of justice. What are the three natural principles of justice are? First one is odi alterum partem. Second one is nobody can be judged in his own case. Third one is reasoned decisions. Then there is review of judicial decisions as well. In Plessy versus Ferguson, there were separate tramways for whites and blacks in the United States. The precedent that was laid down was separate but equals. This was overturned in Brown versus Board of Education, where it's laid down that, I mean, the Supreme Court laid down that racial segregation of all sorts in public places and educational institutions are discriminatory and violative of human rights. Later on, it led to the promulgation of Civil Rights Act 1964. Then, what are the provisions which talk about judicial review? Judicial review under Indian Constitution is implicit. First one is Article 372, which talks about judicial review of pre-constitutional legislation. Example is Section 377, which struck down that consensual homosexual relationships have been decriminalized. That was what was laid down in this judgment in Navtej Singh versus Union of India case in 2017. This is an example for pre-constitutional legislation. Then Article 13, which states that if a law tries to abridge the fundamental rights, then they are void. Example is triple talaq, which was struck down as unconstitutional in Shaira Bano case in 2016. Then Articles 32 and 226. Article 32 is the writ jurisdiction of the Supreme Court. Article 226 is the writ jurisdiction of the High Courts. Then Articles 251 and 254, which talks about inconsistency between union law and the state law. Let us assume that there is this jowar manufacturer who is doing it without having the state permit, and there is a state law which will state that he will be imprisoned for 7 years, and then there is a subsequent union law which will state that he will be imprisoned only for 2 years. Here, union law will prevail over the state law. Then Articles 131 to 136, which deal with the power of the Supreme Court to adjudicate matters between individuals in the state, and the state and the union on the question of law when it comes to civil matters, criminal matters, and constitutional matters. So there are two types of question of fact and question of law. If I am a signatory to a contract, then that is a question of fact. Enforceability of the contract is the question of law. Here, question of law is further classified into presumption of law. Presumption of law are of two types, rebuttable and irrebuttable. Example for irrebuttable is if a child is born within 210 days of the divorce proceedings, then the child will be considered to be the husband's. This is an irrebuttable presumption of law. This has been laid down in the erstwhile Indian Evidence Act under Section 114. Example for rebuttable presumption of law is when under the Hindu Marriage Act, if a husband doesn't appear within 7 years of marriage, then he will be considered to be dead. This is an rebuttable presumption of law because there are two possibilities: he can either be alive or dead. And then Article 137, which talks about special power given to the Supreme Court to review its own judgment. Then what are the case laws which talk about judicial review? First one is Golaknath versus State of Punjab. Here Golaknath had 500 acres of land. Under Punjab Security of Land Tenures Act 1953, certain lands were taken over as surplus by the state. Right to property was a fundamental right back then. The law which was laid down was that the parliament did not have the authority to change the fundamental rights guaranteed by the Indian constitution. This judgment was also eventually reversed by the 24th Amendment to the Constitution, which empowered Parliament to make changes related to the Constitution, including fundamental rights. In Keshavanand Bharti case, it was laid down that Parliament could nevertheless amend the Constitution, but it should not alter the basic structure of Indian Constitution. So, what are the things which come under the basic structure doctrine are supremacy of Indian Constitution, sovereign, socialistic, secular, democratic republic. All these are a part of basic structure doctrine. Then uh, judicial review, independence of judicial review, rule of law. All these are a part of basic structure doctrine. Sorry, independence of judiciary. Then what are the limitations when it comes to judicial review? First one is it never goes forward with the merits of the case. Privity of contract, if it is questioned in a court of law, that is a matter which will affect the merits of the case. Here, under judicial review, the rights of a person will be violated, and that's why he will seek for a judicial review of the decisions already passed by the lower courts. Next is that it is designated only to High Court and the Supreme Court. Then there is failure to comply with the separation of powers concept. Under the Indian Constitution, there is separation of functions rather than separation of powers. This was laid down in Ramzavaria Kapoor versus Union of India case. Here, because of judicial review, the judiciary tries to overreach its jurisdiction and goes forward with the lawmaking function. For example, in Aruna Shanbag's case, it legalized passive euthanasia. It indirectly encroached upon the lawmaking function of the legislature. There is always a tussle between judicial restraint and judicial activism. PIL, then absolute liability were a part of judicial activism. Because of power of judicial activism, these concepts emerged in Indian Constitution, and it became something which is followed even today. Then there is a concept called as locus standi. A person who has filed a case should prove why his rights were violated, and it should be only through him that the rights should have been violated and not through any other person. This is the concept of locus standi. This was done away with the concept of PIL and the introduction of PIL. Then there should be exhaustion of alternative remedies to seek judicial review. This is also one of the other limitations of judicial review. To conclude, judicial review under Indian Constitution is implicit. It was borrowed from the United States Constitution after the Marbury versus Madison case. There should always be a balance between judicial overreach and judicial restraint. Thank you. Do let me know in the comments what are the next topics that I'll have to cover.